We've already formed a quorum. Please invite the government representatives to come in. Good morning, government representatives. This is the meeting of the Bills Committee on Statute Law Miscellaneous Provisions Bill 2014. To save time, I won't introduce you one by one because we've had a number of meetings already. Item 1 on the agenda. Last time we completed the scrutiny of Part 12, Clause 64 of the Chinese version of the bill. Today we'll proceed to Clause 65, that is page C1504 of the Blue Bill. You can turn to the Blue Bill, page C1504. As for the marked up version, it should be page 100. 0100. So please find that page first. I'd like to invite the government representative to introduce the amendment to us. Ms. Yip. Thank you, Mr. Chairman. We'll start with Clause 65 of the Blue Bill. Last time we said that for the previous part, for Chapter 1C, we would like to change the name. So this is a consequential amendment, that is Clause 65. Because in the Land Titles Ordinance, there is a specification that has not taken effect yet. Now, for Cap 1C, the new name will use specification as the name. That is validation in relation to specifications, such that in future, when the provision takes effect, there won't be confusion. So it will be 指明公告 in Chinese. So please continue. Then Mr. Chairman will proceed to page C1506, that is Clause 66. At the last meeting, I explained that we would like to elaborate on specifications, 指明或指定. For the longer sentences, we would like to provide some definitions first. That is in bracket 1. As for bracket 2, it is about application of the section. A Section 43 specification was made by a notice under Cap 1C. Before the loose leaf edition, at the end of 1989, we made that change. So the specification is after the 30th of October 1989, but before the 1st of July 1997. Sorry, it's after the 31st of December 1989, but before the 1st of July 1997. Then in bracket B, there's another provision. That is, the Gazette notice did not add to the Cap 1C schedule an entry to describe the specification. So this is to explain that at that time, we did not carry out the action as now in Cap 1C. And then in Clause 66, bracket 3, we try to effect a remedy. The Gazette notice for a Section 43 specification is deemed to have amended the Cap 1C schedule. This is to affirm that we've properly placed it in Cap 1C. And the commencement date will also be the same as the specified commencement date. In bracket 4, we'd like to address the issue that I described at the last meeting. That is, in the Gazette notice, there's no mention about adding Cap 1C, but in the loose leaf edition, we added that, and later there are laws to amend Cap 1C. So in bracket 4 here, we try to address those amendments. We would like to affirm those amendments in order to avoid disputes or controversy as to whether or not the specifications have been amended. Legal advisor, would you please explain that to us? Well, in the marked up version, we don't have these amendments because there are not amendments to existing provisions. That's why, as Masip said, we have to refer to the relevant parts in the Blue Bill. A further clarification here. In Part 12, they're trying to handle certain specifications to public officers. We would like to know in future how will this be handled. So can we have an explanation on the future practice?
Ms. Yip, thank you. Thank you for the legal advisor's question. After this legislative amendment, Cap 1C, the schedule, will be rationalized. In the future, if there is a need for further specifications, we will introduce amendments in Cap 1C to properly incorporate these specifications. And this also facilitates future amendments because it will be done by amending the schedule under Cap 1C. Any other questions? If not, let's continue. Cap 13, consolidated instruments, is from 101 onwards. Ms. Yip, as the legal advisor mentioned in Part 3, Part 13 is similar to Clause 66. Is not an amendment to amendment to Cap 53B. So you cannot find it in a marked up copy. You will find it in 1510. Well, you'll find the definition in under subclause 2. You will find information related to historical building decoration. Well, it's similar to the previous clause. Well, it relates to the relevant decorations after the revised edition became the loose leaf editions. And it's not an announcement to incorporate under sections 2 and 3 of Cap 53B. Similar to Cap 1C, we use subclause 3. Under section 3, we tackled section 2, and section 4 deals with section 2. Is deemed as the addition of the two provisions into Cap 53B. In relation to subclause 5, it clearly stipulates that it will appear the last item in the loose leaf edition. The last item of the revised edition is 2Y. So afterwards, all the additions will be made after paragraph 2Y. And the next one is to deal with paragraph 3. The last item in the revised edition is paragraph 3p, so all the new additions will be after paragraph 3p. Subclause 7. Similar to Cap 1C approach. In the future, if there are paragraph 2-3 additions of Cap 53B, these additions would have been deemed to have been properly incorporated. Any questions from the legal advisor? Perhaps the administration may clarify one point. And the part 13, we see that there are amendments to rationalize revision to the loose leaf addition. There are three parts here. Can they clarify that they have reviewed existing legislation? And when it comes to consolidation, there are irregularities in relation to these three subleg only, or they have reviewed all other subsidiary legislations in relation to consolidation and found that there is no irregularities in those other subsidiary legislations. We have conducted a review. There are frequent amendments to these three sublegs, so we introduce these in parts 12 and 13. In our review, we have identified three others. There is Cap 61A is the legislative resolution, and it has already been dealt with. There is also another one, is consolidation, is 116B, Cap 116B. We have not proposed any amendments. However, there is still one item that is still in use. And in Cap 116B, the chance for an amendment in the future is slim. Therefore, we did not propose any amendment. After we have spotted the irregularity in 116B, we have gazetted the amendment in the loose leaf edition. And another one is Cap 177C, is the registration of a person, in relation to registration of persons. This is in relation to invalidation of OID cards. There is a provision in the bill to repeal it. Legal advisor. Basically, we don't disagree with you. We would like you to maybe put it in written form for members' reference. Any other questions? If not, we will continue. Is the schedule of country parks destination consolidation order. For clauses 68 is similar to 67. The first one is the interpretation. It says that it applies to the destinations published in the Gazette after 31st of December 1989, and they did not amend Cap 208B schedule by adding an item. And in relation to Cap 208B schedule, the Gazette order is deemed to have amended that schedule by adding at the end of the schedule an item. And in relation to the order that is dealt with in subclause 4. Clause 68 is shorter than the previous two clauses. If you refer to 67 subclause 7, the validation refers to future amendments that they will be deemed to have been amended in proper order. Because in 208B there are only 3 items in relation to the rationalization of consolidation. And after the country park designation has been put into effect, there is no other amendments introduced, so there is no need for us to validate further amendments. Legal advisor, in relation to 68, the first paragraph, the English version is 68 bracket 2A. And you find the draft tabled in front of you. Perhaps when you explain the amendment, you will explain to members. So there is no other elaboration needed from the administration? No. Any questions? Now we move on to part 14, as we've completed part. Well, actually, we have completed part 13. We have already gone through all the other parts. In relation to the English version, legal advisor, any comments? No. If that is the case, we will go back to the questions raised before. On the 19th of May, the legal advisor asked some written questions, and on the 17th of May and the 16th and 27th of May and the 23rd and the 18th of June, there were some answers given from the administration. In relation to those replies, any questions from the legal advisor? What we have looked into it, and I would like to draw your attention to CB bracket 4, A35, 13 to 14 bracket 4. That is in relation to part 7, unsolicited electronic messages ordinance. Is C1430. Is the form of service, and I find that in paragraph 4 they have proposed some alternative, some other drafting. It's in relation to Cap 115 section 37 ZE. We see that in clause 51, the addition of 44 1A under paragraph B is in relation to the date of service. When is it deemed to have been served? It's deemed to have been served on the next day. But in relation to immigration ordinance, section 37 said B, it refers to the second working day. So some refers to just the days, and others the working day. And so there is a difference. This is for your reference. We've also looked into other areas, and we find that in different legislation, say for example, Cap 1, there is a different wording. Say for example, Section 8, it refers to general service. When is it deemed to have been served? In the provision, it says the relevant document if is deemed to have been served by ordinary mail, but it doesn't refer to the date. and the judiciary has issued Practice Direction 19.2. In paragraph 2, it says if the document is posted by registered post, it's deemed to have been served on the 4th working day. If it is by ordinary mail, it's deemed to have been served on the 2nd working day, but that is limited to court documents. And I will refer you to another provision. Is the Cap 487C, this subsidiary legislation in Section 2. There are some provisions in relation to service. It says if service by hand is impracticable, then it may be done by ordinary mail. So there is an order. You will have to first try service by hand. If that is not practicable, then it can be done by ordinary mail. That's for your reference. Any questions? Well, if there are no questions, and in relation to the questions on the 20th and 27th and 23rd, 20th of May, 27th of May, and 23rd of June, we have received replies from the administration. Any supplement from the administration? Ms. Yip? No. Legal advisor, would you like to say anything? Yes. There is one point. We have done some research. It's for your reference. It's CB bracket 4. CB bracket 4A6 to 13 to 14 bracket 2. In the Chinese version, whether the word sun as in a signal, which radical it should use.
嗰度就交代呢。
In paragraph of that paper, the government explains that the son with a 企人邊, that is meaning the person, had been discussed. Under the existing laws, different pieces of legislation have used different versions for the two versions of son. Even for transport-related legislation, for example, the subsidiary legislation under Cap 374, both versions of the Chinese character had been used. We took reference from certain literature and discovered that both versions of the Chinese character had been used. And now, in this bill, the Chinese character with the prefix meaning a person is used. Yes, it should be that one. That's easier. It's not for communication. It's for communication. I'd like to thank your legal advisor for his comments. First of all, in the road traffic ordinance, indeed, both renditions have been used. We'll inspect this issue later. And this time, we've used the character son with the prefix meaning a person is used because we consider that to be more proper. We looked up different dictionaries, some of which are on computers and electronics. In English, if it is signal, the Chinese rendition should be the character with a prefix meaning a person. That's why in this amendment exercise, we've used that character. All right, so we'll adopt that version, that rendition. It doesn't matter. Dr. Priscilla Leung, in paper 862-02, last time we discussed mutual legal assistance. At the moment, we don't have the relevant arrangement. Last time we mentioned the judicial instruments as well as synergy. If I remember correctly, is the 31st of March 1999. You can dig up your record. During the last discussion, we mentioned that, so perhaps you should take that up in this exercise to make it more comprehensive. In criminal law, we don't have that concept. I think Dr. Leung is correct. The commencement date was the 31st of March 1999, but that's about the delivery of instruments between Hong Kong and the mainland. But that's in relation to civil law and commercial law. This time, this exercise is mainly on criminal law. For criminal law, we can affirm that for the time being, we've not made any arrangement. If there are no new questions, this morning the administration has placed a schedule of CSAs from the administration. I'd like the administration to explain the proposed CSAs to us. Who will do that? Ms. Kwok? Is it Ms. Kwok? Yes, Ms. Kwok. Mr. Chairman, we've referred to the views expressed by members in the past meetings as well as the administration's viewpoint. So we've set out in this paper the addition and deletion proposed. In clause 1(4), we'd like to propose an amendment because in part 12 there will be a new amendment. Therefore, we'll have to add in bracket 5 to say that Division 5 of part 12 is deemed to have come into operation on the 9th of April 1998. So that's in clause 1. And then in clause 14, as we previously mentioned, this amendment is related to drafting. That is in relation to sex discrimination ordinance for appealing paragraph G. In the English version, there's only one citation. In the Chinese version, 2. Therefore, here we propose that in the Chinese text, we should add in 所有 before G. And then for bracket 3, as your legal advisor reminded us, we're scrutinizing this bill together with another bill. So it depends on which bill will be enacted first. If that bill gets enacted first, then we'll have to make this amendment because this is in relation to securities and futures ordinance. In November, when we go back to the LegCo meeting, we may have to move this amendment. That's in relation to the evidence ordinance, And then for clause 48(3), in English, it is in that document. In Chinese, is 或該文件. So we have to amend this to read 及該文件. And then for part 7, in relation to unsolicited electronic messages. Last time members asked about the presumption and its application. In terms of drafting, we've proposed an amendment here to more clearly express the legislative intent. This amendment will also make the Chinese and English versions more consistent. We would like to propose the deletion in the English text. The notice is presumed to have been served in the absence of evidence to the contrary. And then we would like to substitute that by in the absence of evidence to the contrary, the notice is presumed to have been served. That is to make it consistent with the Chinese version. And then for clause 52, please stop for a while. Can you read the amendment to the English text? Yes. To delete, the notice is presumed to have been served in the absence of evidence to the contrary. That is in the existing blue bill. So we would like to substitute that by, in the absence of evidence to the contrary, the notice is presumed to have been served. That is to make the two versions consistent with each other. And then for Part 8, clauses 52 and 54, we've proposed certain amendments in relation to drafting. Earlier, your legal advisor wrote to the administration. At previous meetings, he also expressed certain concerns about drafting. We considered the advice of your legal advisor and discussed with the administration and are now proposing these amendments to make the English and Chinese versions more readable and to express more clearly the policy intent. In the existing version, we use subparagraphs. We would like to propose the deletion of subparagraph 1 and substitute it by a paragraph, a whole paragraph. As for the two amendments proposed for clause 54, the original intent of the amendment is the same. That is to express more clearly the policy intent. I understand that your legal advisor has certain views. Yes, legal advisor? Mr. Chairman, for these amendments on these few provisions, we repeatedly discussed with the DOJ, still were concerned. For Part 8, may I refer you to page 1432, page C1432 in relation to 3 clauses. Only amendments for clauses 52 and 54 are now proposed. But in fact, in clause 53, there are similar provisions, but they've not proposed any amendment. That's the first concern. As Ms. Kwok said, we wrote to the administration to clarify the policy intent for this part. May I refer you to clause 52? I actually raised my concern at previous meetings. Perhaps I should repeat myself for your reference. There's a case in the Court of Final Appeal in relation to Trade Descriptions Ordinance and the defense applicable, and it's pointed out by the CFA that the provision was unconstitutional. In fact, the evidential burden is sufficient for the defense. All along, it's for the prosecution to prove beyond reasonable doubt the charges. So if you analyze the precedents in the Court of Final Appeal, we'll see that we don't have any difference from the administration's standpoint in relation to the intent. But as for drafting, can we express more clearly the policy intent? That's our concern. May I refer you to clause 52? Just look at the newly added section 1222 capital A, Roman letter 1. The defense has to produce evidence A, B, and C, 3 points then. And then for Roman figure 2, that's about counter evidence. That is, the prosecution has to prove beyond reasonable doubt the charges. And previously we raised the concern that if counter evidence is produced by the prosecution, does the prosecution have to prove A, B, and C, or just one of the three? For example, just C. So we would like to clarify the policy intent as well as the interpretation of the CFA judgment. And we're told that the prosecution only has to prove A, B, or C. That is one of the three. But given the draft here, the word "and" is used, so there is a chance for the prosecution to have to prove A, B, and C, and that's not the policy intent. As for the proposed CSA, it is different from the existing draft. That is, no more A, B, and C. The three form one sentence now under the proposed CSA, but still the conjunction "and" is used. So if the prosecution is to prove beyond reasonable doubt, does it have to prove A, B, and C, or just one of the three? So this is our concern. So this is for members' consideration.
Ms. Priscilla Lau, I would like to hear from the administration to the point raised by the legal advisor. Well, we have had a number of exchanges with the legal advisor. Let me tell you the view of the administration. We have to look at the issue as a whole. It has to contain all the elements. If it says
嘅時候呢，係講緊呢一個 issue 有任何一個部分呢，
it refers to that if any of the element is not proved, the prosecution has discharged its burden of proof. When a CFA explained the case, it says that the prosecution only has to disprove any one of those to take the defense apart. There are similar provisions in other legislations. They used a similar drafting. 43Q in the Employment Ordinance, Section 44 of the MPF Ordinance, Section 141 of the Lifts and Escalators Ordinance. The accused has to prove more than one element, but we're still talking about.
我哋都冇喺草擬度好清楚咁樣再講明，就話佢要只係呢。
So the prosecution only has to prove either one of those. And in the drafting guide of published in 2012, there is an example when drafting provisions related to evidential burden, how it should be handled. In similar provisions, we would like to use the same drafting approach. So we don't want to use a different approach because it will have an adverse effect on other provisions, because people may think that a different drafting approach may imply a different intent. If I understand the legal advisor correctly, the way it's drafted gives rise to the impression that A, B, and C have to be proved for it to be beyond reasonable doubt. But the administration's explanation is that it doesn't have to be drafted in any other way, because when there is a doubt, there is a doubt. We have listed a number of legislations. Yes, that there may be a list of, say, A, B, C, and in the end you use the same approach is beyond reasonable doubt. Well, for two pieces of legislation, the defense will have to prove both A and B, and the prosecution will have to offer rebuttal. Well, how come that is different when there is a C? We're not talking about just one item. It's at least two. So whether it's a 3, 4, or 5, we use the same formulation. If you read it, you cannot read it in another way. We think a better approach is to use a consistent approach. Mr. Liao, you would like to say something? Or you still don't understand? Okay. Legal advisor, would you please explain it again? Or perhaps you will also reply to the administration's answer. I think itself is clear. They said that they have already taken your concern into account. It is in relation to C1432, Part 4, clauses 52 to 54. To reply to Ms. Leung's concern, we have done some research with the administration. My view is that it is for the other provisions is not as complicated as this one. The elements to be proved usually is just one, so the contrary is very clear, one. And the provisions mentioned by Ms. Kwok contains only two elements. But here, for 52, say for example, there are three elements, A, B, C. The administration did not propose any CSA in relation to 53 because for Roman 1 is A, B, C, D, E, and Roman 2 just A, B. So you see that the current provision is more complicated than the others. So we're concerned that when the prosecution has to prove to the contrary, the current drafting approach may give rise to an interpretation that the prosecution will have to prove A, B, and C. Ms. Kwok. There is a CFA case. So when it comes to interpretation, we are quite sure. We don't worry about it because this is not an amendment in substance. We just amend it to an evidential burden, not a legal burden. We think the CFA ruling still applies. So under the original provision, there has already been a CFA decision. Legal advisor talks about only two elements appearing in the other provisions, but those two elements are not simple ones. So the complexity does not correspond to the number of elements. As Ms. Leung said, the prosecution only has to raise a reasonable doubt. So contrary is not proof for the contrary is not proof beyond reasonable doubt. I think itself is clear enough. Well, 53 is not touched. Well, we have made a suggestion to the DOJ. If you refer to 52, the newly added 2A, A Roman 2, this is in relation to prosecution having to prove to the contrary. So it's A, B, or C. So you only have to prove either, to prove any one. This is worded in a negative way. So it's proof to the contrary, none of those A, B, or C. There is no difference between views of the policy intent and the CFA decision. It's just that the current way is worded may give rise to misunderstanding. Well, if all the elements are listed out, then and the way it is worded, it seems to give the meaning that all of them will have to be proved. We have considered the legal advice's view, and we have also explored an alternative way to draft it. That's why we introduced CFA, and we have proposed a different approach. If we say contrary of A, B, or C is not proved, then there is a loophole, because if we say A, B, or C, we have to use more words in the draft. It will make it more complicated. And we're talking about looking at the issue as a whole. Is whether you have the knowledge when you use infringed products or products with wrong trade descriptions. Now that we have separated them into different paragraphs, it will be, well, previously though they were in paragraphs and it may not be easy to understand, so we introduce a CSA, says to the contrary. So if there is any doubt, then the case is not proved. So we have introduced amendments after the legal advisor has given us his opinion, but it's just that we have not taken on board his suggestion of how it should be worded. Mr. Liao, I want to ask 52 to capital A, A Roman 1. A did not know, B had no reason to suspect, and C could not with reasonable diligence have ascertained. The administration's intent, is it to be conjunctive or disjunctive? The policy intent is for the defense to prove all three elements. Legal advisor. In relation to consolidating them under one paragraph, you think that it still fails to address your concern, correct? It's now consolidated into one paragraph. The connective is still the word and. The prosecution has to adduce evidence to raise an issue. But when the defense rebutted, so as long as the defense can prove capital C, so the prosecution may not be able to prove that the defendant disprove that the defendant did not know or had no reason to suspect. The prosecution only has to prove that with a reasonable diligence the defendant could have known that there is a falsified trade description, then the defense will be convicted. So when here it says sufficient evidence is adduced to raise an issue, it gives the impression that perhaps the prosecution has to prove all three elements, but the administration's explanation is that is any one of them. You see that there is a misunderstanding. Although with the CSA is now consolidated into one single paragraph instead of listing them out as A, B, C, but there is still the connective word and. And in clause 53, I understand that if it is to be consolidated under one paragraph, it will be rather lengthy. We see eye to eye with the administration when it comes to the legislative intent or the policy intent, but as to how it's drafted, we do not agree. Ms. Priscilla, the legal advisor sticks to his gun. Well, under clause 53, we see more elements, A to E. You see that is and. Say, for example, for small a, all five of them have to appear. Well, we did not know before that it is any one of ABC or all three ABC. But now we know. I would like to ask you whether you would consider standardizing them.
I'd like to go back to the legal advisor's point. You say here the contrary is not proved by the prosecution beyond reasonable doubt. Even in common law, we understand that so long as there is a doubt, then it is not beyond reasonable doubt. By reasonable doubt here, you must mean A, B, and C. Would you add any one of the above? Thank you, Dr. Liang. In the existing draft, in relation to the onus of the defense, we make it very clear that it should be A, B, and C, even in the existing bill. As for Dr. Liang's comment, it is similar to your legal advisors. Earlier, I did explain that in existing pieces of legislation, there are provisions that have used this drafting approach. So we're concerned that if we shift to another drafting approach, there may be a read-across effect on other pieces of legislation. So we have a worry here. A couple of days ago, we referred to a New Zealand provision which adopts the same approach with three factors of consideration. Their drafting approach is the same as ours. So in Hong Kong, within our jurisdiction, we would like to make everything very, very clear. So we'd like to maintain consistency. Therefore, here we have not proposed any drafting amendments. Well, you repeatedly said that there are a similar approach is adopted in other provisions. Can you give us the details? Well, I have them here. Yes, please pass them to members. Yes, Mr. Chairman, I believe in New Zealand they do adopt that approach, but that doesn't mean that New Zealand is correct. Now, the contrary is not proved. What do you mean by contrary? All the three elements or one of the three only? What is your intent? Ms. Wan? May I refer you to capital A and then bracket small letter a. Sufficient evidence is adduced to raise an issue that the person charged A, B, and C. A did not know, B had no reason to suspect, and C could not, with reasonable diligence, have ascertained that the goods are with false trade description. And the prosecution has to prove the contrary beyond reasonable doubt. And there are three factors of consideration here. That is, the defense has to prove the three elements. After discussion, our conclusion is that the existing draft is clear and acceptable. Of course, we understand the point of your legal advisor, that is to further clarify the provision. That is, the prosecution's counter evidence is to prove one of the three. So it's no longer a trinity, right? If the prosecution can counterprove one of the three, then the original arguments would not be able to be established. So we agree with your legal advisor that the policy intent and our interpretation of the CFA judgment are the same. But in terms of drafting, our drafting division is the expert. Of course, there's nothing wrong to make it even clearer. We understand that in Hong Kong, in other pieces of legislation, the provisions may not be similarly complicated, but still a number of factors have to be considered. Here, the defendant has to prove that it is acted not attributable to the person's neglect. So there are two factors. But for the prosecution, it's not either of the above or one of the foregoing. So the major issue here is that if we take the lead to change the drafting approach to clarify the provisions, then what about the provisions in other pieces of legislation which are not clarified? There may be discrepancies or inconsistency then. So basically, the contrary is not proved by the prosecution beyond reasonable doubt is the requirement. So we're of the view that the existing draft is clear enough. Dr. Priscilla Leung, one more question. Now, originally in the Chinese edition and the Chinese version in the Blue Bill, you use a semicolon. Well, that's why we're proposing this CSA. Yes, that is to do away with A, B, and C and put them together, separated by commas. So are you going back to the previous version? Am I correct? You want to re-amend your amendment? Well, originally we use semicolons, and now we have a consolidated provision. Previously, we separated the three factors by semicolons. But apparently that's not clear enough, so for this proposed CSA, we have adopted a consolidated approach. As Ms. Wan said, there's a controversy here. and we have to adopt a comprehensive point of view. So you would like to revert to the original draft? Yes, the original drafting approach is clearer. Members, any comments? Do you have precedents? You quoted provisions in other pieces of legislation. Yes, it should be beyond reasonable doubt. So long as there is a doubt, then it is not beyond reasonable doubt. Can we have the details for other provisions in other pieces of legislation? So it's very clear. Any one. I'm looking at your original amendment. Did not know and had no reason to suspect should be combined. Am I correct? As for precedents, for the time being we've not detected any precedents. We can go back and further examine whether or not there are precedents. In any way, it has always been A, B, and C. Mr. Martin Liao, I'm still on 52, 2, bracket 2, capital A, and then small letter A and Roman 1. There are 3 elements. If I remember correctly, in many pieces of legislation, the disjunctive approach is adopted for cases in which there are different elements. Because this is not the first appearance of these 3 elements, I'd like to know whether the general approach is a disjunctive one. In fact, whether or not these elements appear together or separately, we don't have any drafting policy. It depends on the drafting instruction that we receive. So why is the policy a disjunctive approach and not a conjunctive approach? Well, here we're talking about knowledge. For Section 12 of the ordinance, it said that you cannot import forged trade goods with false trade description or forged trademark. So you can put up defenses. The defense can say that he did not know, had no reason to suspect, and could not with reasonable diligence have ascertained that the goods are goods to which a false trade description or forged trademark is applied. So it depends on the nature of the offense, and sometimes this can be put up as a defense. Mr. Chairman, very simple. Capital A is very simple, did not know. Well, it's possible to have A plus B or A plus C, but then between B and C, it's not necessary to prove both in order to put up a defense, because had no reason to suspect and could not with reasonable diligence have ascertained are very independent defenses. Of course, all the 3 elements can be independent, but A plus B or A plus C are similar to general or common circumstances, but B and C are rather independent. If you are to prove all 3, that is A, B, and C, is rather difficult. If I remember correctly, if you're correct, in some pieces of legislation, the disjunctive approach is adopted. Ms. Wan? Mr. Chairman, in this exercise, we're proposing these amendments on the basis of a CFA judgment. On page 0061 of the marked up version, you can see that it is bracket 2 capital A. In the Chinese version, the word 且, which means and, is used, and the same 3 elements are used: did not know, had no reason to suspect, and could not with reasonable diligence have ascertained. So the 3 elements have not been changed. So we are putting all the defenses back into the proposed CSA. So the onus is the same, the elements are the same. Members, what do you think? The legal advisor would like to further clarify the provision, but then the administration is of the view that the existing draft is sufficient. Well, Mr. Chairman, we have to make a decision. Legal advisor will have to base on the CFA judgment. With the original version, I have the original version here. I think the CFA also considered these 3 elements in passing the judgment. The Chinese version is very clear with the proper punctuation. Now, the CFA has not changed those elements. Still, the conjunction and 且 is used.
Now, some words are changed. So at that time, some words are changed because it was material. Is that the case? Miss Lam, you're referring to... Well, we have copied and pasted the original wordings. No, you have changed the words by replacing him or her with the defendant. Well, the original approach is a legal burden approach, but now we change it to evidential burden approach. First, you have to raise an issue. Second, the onus of the prosecution. The material remains the same. The substance remains the same. Since we now have to be gender neutral, we will not use the word he. We will say the accused. To make it clear, you mean yes. The CFA decision did not change any substance in the wording of the law. It's just that it's now clearer in relation to the onus of proof and the onus of rebuttal. I'm still referring to 52, 2 capital A, and a Roman A, the 3 elements. Well, A and B are subjective. C is objective, I think. Is that right? B and C. Between them, is there a conflict? B says had no reason to suspect, and C could not with reasonable diligence have ascertained. So if there is no reason to suspect, you will not take reasonable diligence to ascertain. If there is reason to suspect, then you will take reasonable steps or do it with reasonable diligence to ascertain. I don't know whether there is any conflict between this subjective element and the objective element. Can you help me? Miss Wan, let me try. We're talking about a false piece of goods or a false trade description. The law enforcement officer. No, I'm talking about just the use of a falsified trade description. The current legislation is an absolute liability, but there is a defense. The defense will have to prove three things. First, subjectively, I did not know that it's a falsified trade description, and subjectively, I had no reason to suspect. And the third thing, which is you just close your eyes, not do anything to ascertain. That is objective. If you just close your eyes, then there is no reason to suspect. It's not the case. If you don't care about anything, there is still the subjective aspect, which is that if you, with reasonable diligence, could have ascertained. The defense will have to prove all three things before he can be acquitted. That is, subjectively he did not know, and subjectively there is no circumstantial evidence to show that he knows. He has to prove all three before he is acquitted. The CFA did not change the elements of the offense. The only change is that there is the third element, which is a subjective one. It is whether he knew or had reason to suspect or not. If someone has exercised reasonable diligence, would ascertain, and that is not done, then he would be convicted. The defense has, the prosecution has the onus of proof, that it should be proved beyond reasonable doubt, always remains on the prosecution. So if you defeat any of the points, then the defendant will be convicted. But 53 is not changed. I think we need to make a decision. What the legal advisor said is very reasonable. You have read out a number of provisions using the same approach. You have to consider whether to improve them in the future. And 53 is not changed. We have to make a decision anyway. Legal advisor. Well, there is no amendment to 53, but there is a CSA for 52, but the CSA does not address your concern. So, in your opinion, is it ideal to introduce that CSA? Perhaps the administration need to furnish further information about existing legislation. As I said, and when it comes to the policy intent and the CFA's analysis of criminal liability, we see eye to eye with the administration. We are only concerned about whether the current drafting approach accurately reflects that. We have a duty to the Bills Committee. We have to put forward our concerns. And in relation to Clause 53 not being changed, we have actually had some discussion. The CSAs to 52 and 54 relates to putting everything under one paragraph. The connective is still the word and. If I'm asked, I would say that the CSA does not completely address my concern. I understand that it will be difficult for the administration to put everything under Clause 53 in one paragraph because it will further complicate it. And yes, it is bizarre that 52 and 54 have been changed while 53 remains the same. Ms. Kwok, Clause 53 is Section 26. So when it comes to the defense, there are two elements, and it's expressed with the word and. It's not appropriate for us to put Roman 2 in one paragraph. So it's not the case of inconsistency. We have to choose the most suitable drafting approach. It's not the case that we deliberately left out 53. 53 refers to Section 26. And under the existing section, they are separated, A and B. But here, under Roman 2, it says very clearly that is or and. I know that with the existing version, that the Chinese version, the punctuation is different from that appearing in the blue bill. In Clause 53 in the current version is set out in A, B, C, D, E. 53 is more complicated than 52 and 54. Well, under 1, for Roman 1 and 2, they have to be both satisfied, but under Roman 1, out of the 5 elements, only 1 has to be proved. So for the defendant, this is a clearer approach. If we put it under one paragraph, and if you think that it is equally clear, we will consider that. Just to convey a sense of consistency in format. Contrary means contrary to what the defense has raised. Can you say contrary to the above? Say 53. Under Roman 1, the elements are disjunctive. The burden of rebuttal is to rebut the evidence put forward by the defense. Can you simply say contrary of the above is not proved? Legal advisor. Well, it's contrary to any of the above. The 53 is complicated. The rebuttal burden is to rebut the evidence adduced. For 53, under small a, Roman 1, among the different elements, the relationship is or, but between Roman 1 and Roman 2, the relationship is an and. While under Roman 2, between elements A and B, the relationship is or. So I understand that 53 may not be as clear if it is amended to the way clauses 52 and 54 are. Yes, I agree. If you have to change, it has to be changed to contrary to any of the above. And you will have to add a lot more to it to make it clear. Can we talk about 53? We are already talking about 53. I do think that it has to be consistent. Otherwise, there will be other problems. I'm not very sure that the current approach means any of the above as reflected in a case. Contrary to the above. You don't have to say any of the above. Because the rebuttal is to rebut the defense evidence. So contrary to the above, it suffices. There are different ways with Mr. Leo's contrary to the above and the legal advisor's contrary to any of the above. We will discuss with the legal advisor to see if there is a fourth approach. We've spent quite a lot of members' time on this. We understand that in different ways there will be a different view. Perhaps the legal advisor will look further into it with the administration. The current way is not ideal. I thank you all for your time. You please give us a written reply. Yes, I will further explore it with the legal advisor. Well, I will ask the legal advisor to follow it up for us. We haven't finished with the CSA.
跟住下一個嘅委員會審議階段修正案呢，就係關。
Well, we'll proceed to Part 10. And Ms. Wen at previous meetings said that With reference to the Law Society's comments, we'll now withdraw the proposed amendments for Part 10. And then, for Clause 63, as the commencement date will be very similar to the new company's ordinance, adding to Cap 1 subsidiary legislation. Therefore, in the interim, we would like to propose a CSA by adding Division 5 Specification of Public Officers, Cap 1 subsidiary legislation C. And then for Clause 64, we would like to propose the deletion of part and substituting it by section. And for Clause 63, to add Registrar of Companies, Other Companies Ordinance Cap 622 after Registrar of Companies, Registered Trustees Incorporation Ordinance. And a new clause to be added in Part 12 by adding Division 5 Specification of Public Officers, Cap 1 Subsidiary Legislation C, amendment relating to Books Registration Ordinance, Cap 142, and 66 capital A Schedule amended. As your legal advisor pointed out, there's an inconsistency for Clause 68 bracket 2 bracket A. So we propose that in the English text we should delete and before and substitute it by but before. And then a new clause in Part 14 for the Commissioner of Customs and Excise. All will be amended. The existing version used the old post title, so a new CSA will be moved to amend the Chinese version to 海关关长. And then there are also amendments in relation to United Nations sanctions. We now propose 3, and before the LegCo meeting, if there are more to come, we'll move further CSAs. All right. Members, legal advisor, any comments on these CSAs? Members? No? Then, save for clauses 52, 53, and 54 with no more comments on the bill. So perhaps the legal advisor should further discuss with the administration. And we'll see whether any more meetings are necessary. As we said, we would ask the administration for a paper to elaborate on those points. As for clauses 52, 53, and 54, if the administration decides otherwise, then an explanation will be necessary. So, unless there are further issues to be discussed, we'll have no more meetings. And a report will be submitted to the House Committee in October. So we'll have another written paper. Yes, that's correct. And we'll see whether members and the legal advisor further comments on that paper. Then we'll report to the House Committee in October in the hope that the second reading debate can be resumed in the next session. So thank you very much. Meeting adjourned.